very much. Everybody hears me?
Yes, I think so.
Right, very good, very good. So it's sorry for being late. We in fact had very much in line with the introduction. We had a government session about the wearing of these protective masks in Finland, which has been a little bit hot topic, and so it proved out to be a bit controversial. And so it took some time, but a pleasure to be able to join you and so on. So a few remarks on the topic, and then hopefully very lively discuss in the spirit of ELSA. And these are like shared experiences from my practice in Finland in this function that Lenita just shortly described, where I'm more or less responsible to being the supreme guardian of the law and the constitution, and therefore also the rule of law issues related to this kind of state of emergency. Second point is that the rule of law is particularly tried or tested under a state of emergency, like in many of our countries have been the case. And not only that, but we have a new type of emergency in our legal thinking about the states of emergency. We quite often speak about the civil unrest, more like the situations like in the US now in the aftermath of this police violence, or in Europe in the kind of wartime situation, threats of war, or in France, some other Central European countries after this terrorist attacks. But we have in fact a new kind of emergency, which is a health emergency. In fact, this is in fact not a new thing. It's a return of an old threat. This pandemic diseases used to be once, twice in a century throughout European history. And if you read about very old laws in France and many countries, I know you find traces about quarantines. In Finland, there have been some quarantine islands where people who were put on the quarantine were put, and so there are these kind of stories about some remarkable epidemics. So this is in fact a kind of return to the distant past, which we have somehow forgotten at some stage with the advancement of the sciences. So this is not a kind of classical state of emergency either, and I come back to the point because it's interesting for us as lawyers. And the second point, it's surprisingly easy to speak to all of you, not only because we share this experience on ELSA and this diversity and this ELSA philosophy, this cultural dignity and this great thing, but it's generally speaking very easy to speak to you as one European lawyer. In fact, our communications in fact do fail in the same way. The communication always fails, but we do disagree, we do misunderstand in a curiously common way. And namely, we have a rather common structure of legal thinking in Europe. And speaking about this particular topic, so I have found two rather recent documents from the Council of Europe, which is a truly fascinating European institution. Very much enlightful for my daily work. And so I would say that there is a European common core of the concept of the rule of law, which is creating kind of togetherness among European lawyers. And this is defined in the Council of Europe documents, and particularly two very useful documents are, there is an information note from the Secretary General of the Council of Europe from this April about some guidance and guidelines to the European governments, how they can apply the state of emergency in this COVID-19, this coronavirus epidemic. Second very useful document, there is a compilation of the practice from the Council of Europe expert body, the non-constitutional law, the so-called Venice Commission on this rule of law and state of emergency, and in the context of this epidemic. So these two documents have been rather helpful also in the daily practice, and also structured this kind of short practical examples on the basis of that. The point there is that the rule of law is much more than the simple fact of of something being formally legal or this kind of formal legality. It's in this document there is a discussion that it's the material rule of law, which means that there is this legality. The law can be anticipated. It creates legal certainty. There is an effective application of fundamental rights defined in the Constitution. There is an effective applications and incorporation of international human rights, and there is effective access to justice, and that these legislations, these laws which are applied, even these emergency laws, they are result of a democratic and open participation process. So that's the kind of Council of Europe understanding of what the rule of law is, and it's shared in Europe informally. 835 million Europeans to material the whole of Europe. Of course, it's to the extent of which it's realized in various countries, it's different, and some legal traditions are different, but I would argue that there is a common core, and it's also related to states of emergencies. My third point is that what is particularly difficult in this state of emergency as a lawyer, myself as a lawyer, and it's the interrelationship of the law with the other expectations in our society. The law is about certainty, legal certainty. Law is supposed to produce legal certainty. Those of us who are charged with like a contract drafting, so it's about risk management, but it's also about to produce a certain certainty in the legal relationships. So the certainty thing is very much in the air. In this kind of classical practice guidelines, also what the rule of law should be in the states of emergency, I'd say that it's the rules which are rather precisely and in a kind of anticipatory manner in the law, and if there are derogations, these are narrowly defined and they are narrowly applied, and there are kind of strict criteria about the legality. More or less, so the law is about a good life. So I think the people who have a background in ELSA understand very well what is a good life, and the law is about a good life which can be anticipated, and there is a certain sense of security. But now the difficulty with this COVID-19 is that we have had a very unknown threat. In fact, in many of our countries, including Finland, we had a difficulty in the beginning to understand what kind of disease we had in face of us. So we a bit realized too late. Some of our countries were better than some others. Finland did quite decent, but it was quite difficult. And what is there difficult is how we can create this kind of legal certainty in a situation where we in fact do not know what we are dealing with, and we certainly do not know anything about the future and how this epidemic is evolving and developing, and what kind of disease we are talking about. So for myself, as a personal experience, it has been like a thrilling story to work with doctors, work with epidemiologists, working with social scientists, working with social psychologists about how the general public will react to different kind of legal rules, and to apply all these multidisciplinary skills and societal knowledge with the side of the legal knowledge, and that has been quite difficult experience, particularly in this upholding of the rule of law, because we the lawyers, we tend to demand for that we need to be precise, and if there is a choice between a restriction and freedom, so we should always stand by the freedom. So that's also the rule of law. But this time we have a little bit less this kind of situation where we have a choice between the freedom and restriction, but we have a choice between the protection of health and life compared in a certain uncertain knowledge. And this has been a particularly difficulty and challenges in my practice in Finland. My fourth point here is that the state of emergency, it's classically it's a kind of exception to the norm, but the Council of Europe, the case law of the European Court of Human Rights very clearly says that the state of emergency shall be governed by law itself, and the law shall prevail. So the definition of the emergencies in law should be defined in a prior way in constitutional laws and legislation, and there should be checks and balances which are verifying that it's not like a sovereign prerogative, but a situation which is defined by law and applied in accordance with the law, so that the law is in the end prevailing. What the case of Finland is that there is a constitutional requirement that it has to be always defined the criteria declaring the definition. Of the criteria of declaring the state of emergency shall be defined in law, and there is a double legal control over it. First of all, the declaration of the state of emergency is, in the case of Finland, happening in a kind of parallel work by the President of the Republic, who in Finland is primarily ceremonial, but have some important roles in relation to foreign and security policy and appointment to the justice and some other domestic case. So the President needs to agree, but it's the government who, applying this criteria by law, have to do it. And there is also the very specific role for myself to verify that these conditions over there are there. And in fact, the Constitution itself saying that it shall be a threat which is threatening the existence and the life of the nation. So like a serious disease as such is not sufficient, but it has to be something which has a huge impact on the nation. So do that assessment in the right time. With an unknown disease was a rather hard pick. In the Finnish checks and balances is that the government needs to pass this application of the state of emergency to the parliament, and there is the parliamentary control over it. And in the case of Finland, there is a specific parliamentary committee, which is the constitutional law committee, which is then going through it, and they have done a very rigorous job in that. In this assessment of whether or not you can uphold this state of emergency. But there are also some, once it has been declared, so then there are these emergency measures, and in our system, in the primary prior control, it has been my services who have been doing this judicial scrutiny, doing this kind of legal scrutiny and constitutional scrutiny of this decisions on the governmental level. And in addition, there's for many of the measures, our legislation recognizes there is a judicial scrutiny. So, for example, we have had this closures of public events, etc. So these have been subject to the scrutiny by the courts. To my knowledge, they have not yet been challenged, but there is this still the point that the courts should be able to function and make this scrutiny of this decision having an impact on the individuals. There shall be a legitimate aim for the measures, not only generally, but for every single measure in the state of emergency, and they shall be temporary. And this need for application of this emergency legislation shall be constantly assessed, and these derogations be kept to the minimum. For example, in Finland we made restriction. We had the restriction that in the southernmost region in Finland, including the capital area Helsinki, we had a more serious threat of this disease than rest parts of the country. So consequently, in the end of March, we started to apply this restrictions of the movement inside Finland, where the movement from and movement into the region of Uusimaa, including the Helsinki, the capital region, was legally closed. And then the government organized in a way that every 2 weeks we were following up, and we had, after this Easter holidays, a session where this epidemiologic indicators show that the situation had calmed quite much down, and so then the issue was whether it was still necessary to have this restriction in place. And I gave a legal advice, in fact legal interpretation, that this should not any longer be, and following that the government lifted this emergency measure. And it was hard for a lawyer to interpret this kind of indicators reported by the health experts, and there was some public criticism about this lifting decision because people were fearing for their health and lives, but retroactively it was very right decision because there was no impact of getting the situation worse. In fact, in Finland we managed with these restriction measures to keep this so-called ELSA, this how many people one contaminated person is further contaminated. It was around 2.4, and so now it's 0.7, which means that this epidemic is going down in Finland. Then there is additional, and this is my fifth point, there is the principle of normalcy. So that always when you are living in the state of emergency, every time you are taking the emergency measures, there shall be an assessment and a reflection, whether in fact the ordinary legislation, ordinary powers would do well. And this is in fact what we are doing now. For example, we had this closure of the schools and school buildings, and the kids and the students, including university students, were moved on this kind of distance learning, and now we did open, in fact, the primary schools for the last 2 weeks, because there was sufficient indicators showing that there will be no particular danger, but there is still this danger of the second wave of this disease coming, and so now we are planning. In fact, this is something that the government is making a formal proposal tomorrow to the parliament, that there will be an amendment of the ordinary school legislation which would enable the schools and regions to move on to this kind of distant learning as a learning mode, so we would avoid this kind of emergency situations where under the state of emergency the schools need to be closed. Two very important principles on this European level, and which has been subject to daily scrutiny in the review of the reasoning for all binding decisions and binding legislation in the constitutional review, and which is also what the authorities and then the courts are reviewing regularly in the judicial review, is the necessity and proportionality of the measures, and that they are necessary, this kind of restrictions, and they are proportionate to their aim. And that is. My final 2 points are that we are dealing with the population, we are dealing with human people, and so there is a lot of power for the recommendations. And some people have been wondering about this kind of how some European countries are dealing with the thing. But our experience in Finland has been that this kind of soft way of giving recommendations is rather powerful, but it's powerful only if you do reasoning behind it, and you open up why. People tend to prefer rather clear norms and recommendations, but they also need to know why. And this why question is very important. And this is done now recently very much up in my practices, that there is issues of access to data, this epidemic data. There is a need of access to information. So people need to have knowledge why the public is asked to behave in a certain way, and why the government is doing things in a certain way. And addressing this issue of why, and this legitimacy point is very important. This is coming down to the issues of access to data, for example, by the media, which have been recently up. And lastly, 2 points. There is a very interesting point of this kind of balancing between the health aspect and health protection aspect and other fundamental rights. That yesterday, for example, I gave my formal opinion on this prior review of this legislation concerning this mobile tracing and warning applications, where the issue is this privacy and the protection of personal data versus this protection of health and prevention and warning if you have been putting yourself into the risks. And once again, this kind of European dimension is very, very important. There is a rather good European Commission recommendation for the European Union on this kind of tracing applications, and guidance from the Wojciech's bureau, in fact, the European Data Protection Boards, and this all this community of data protection officers, which enables, in fact, to do this thing while respecting the privacy, which is pretty important thing. And the final point, where we also as a kind of intellectual influencers in our local, national, and also international level, all of us who are on this alumni movement, I will call everybody work on this, that this state of emergency is a reminder of why global public goods, things like public health, good health system, and the health security really do matter. And we really need a global rule-based cooperation to further develop this vaccine and prevention of this kind of threats. And this is also a legal issue, because if we are successful on that, so then we realize also this principle necessary measures, we can lift the states of emergency and move on to this kind of normal health life, which under this material rule of law is very, very important. We are a little bit concerned about what is also happening in this international World Health Organization. The World Health Organization have been now needed more than ever. No country, even the big countries, cannot solve this kind of thing. So guys, these are short reflections from this kind of practice. Every single 8 points I shared with you have been supported by very practical legal, this is also legal or constitutional assessment we have been doing with my tiny crowd of 34 lawyers here in Finland.
I think we're waiting for Lenita, who's chairing this, Tuomas, to come over and.
Yes, thank you, Patrick. No, I'm here. So thank you very much, Tuomas, for this very, very insightful presentation, and amazing to hear. I mean, from somebody like yourself who's so closely involved in really how to ensure the respect of rule of law under a state of emergency, which is a very extraordinary situation, and not all countries necessarily have this kind of possibility to launch a state of emergency. The neighboring country, Sweden, for example, doesn't have this possibility, and a lot of discussion has been going on what this means. So with this, the floor is really open to all of you to ask questions. You